Good afternoon, and thank you for joining this Benefit Express webinar. My name is Julia Goebel, and I'm Chief Marketing Officer of Benefit Express. It is now 1 o'clock Central, and we'll begin in just a couple minutes to allow more people to join. Once again, thanks for attending this webinar, and we'll begin in just a couple of minutes. Good afternoon, and thank you for joining our webinar, COBRA, What Employers Need to Know. My name is Julia Goebel, Chief Marketing Officer of Benefit Express, and I will be your moderator today. A few housekeeping items before we begin. If you missed something, don't worry. We'll be emailing you the recording with the slides after the webinar concludes. During the webinar, I'll be keeping you muted to avoid any background noise. But know that we will pause throughout for questions. Simply type your question in the box on the chat screen, and I'll read it aloud for you. If we don't get to your question today, we will be sure to email you a response. Now I'd like to introduce our presenter. ERISA attorney Larry Grugin is our presenter and discussion leader today. With more than 35 years experience in employee benefit law, Larry has a wealth of experience in dealing with qualified plans, health and welfare, fringe benefits, and executive compensation areas. Thank you for joining us today, Larry. We are thrilled to have you. And with that, I will now hand it over to Larry to discuss a topic that is surely on everyone's mind. What do employers need to know about COBRA? Take it away, Larry.
Julia, thank you very much. This webinar is going to be presented slightly differently than I've done in the past. I usually have very detailed slides, and you have to listen intensively to catch everything. And sometimes I catch myself reading the slides. I mean, it's hard not to. I'm going to try something differently this time and see if you like it, and I liked your feedback on this. Instead of having very detailed slides, what I'm going to do today is cover a number of topics, wide range of topics on COBRA. But what I'm going to do, instead of feeding you the answers, I want to tell you the answers. I want to have a series of questions. So you can take notes when you get the recording, listen to it again. But this gives you an opportunity to kind of understand exactly what's happening. I'll be explaining my answers. And when you see in this slide, this is what I'll be discussing today. I'll be talking about benefits subject to COBRA. And these are areas I get from my clients all the time in my practice. People ask me all the time these areas that COBRA, and COBRA can be very complicated. So I'm going to be talking about benefits subject to COBRA. Do we have to give it to certain benefits? And that's always a quandary. When does COBRA apply? I'll be talking about who's eligible for COBRA, and also the coverage requirements. Some of the issues that come into play when you're trying to determine what coverage you're going to offer to the employees. How do you determine the premium amounts? Next, I'll be talking about mergers and acquisitions. There's some very complicated rules when your employer acquires someone, you become acquired, exactly what the employer's responsibility. And let me tell you, this is one area of mergers and acquisitions that the corporate attorneys don't know about. And you have to kind of inform them, hey, we may have some COBRA liability here if we don't do this right. Also, I'm going to be talking about COBRA and Medicare. There's some very detailed rules in regard to that. There's some special rules, for example, in regard to health FSAs and HRAs. Also, in what situations can you drop COBRA coverage? There's some specialized rules in regard to that. Also, what do you do in very common mistakes that apply in regard to COBRA? Then I'll take your questions. But what I've decided to do is, after each of these areas, I will stop for questions, especially if you have a follow-up question or you want to know more about what so I'm willing to go into more detail. You know, we're limited by time. I want to try to end by 2. And so if I see I'm spending too much time in one area or another, I may speed it up a little bit. But I'll try to get through this as quickly but as thoroughly as possible. So the first area I'll be talking about, which of these benefits is subject to COBRA? And I have listed here medical, dental, vision, voluntary benefits, wellness benefits, employee assistance benefits, telemedicine benefits, short-term disability benefits, dependent care benefits, HRAs, health FSAs, and qualified small employer HRAs. So here's a whole list of possible which ones are subject to COBRA. Of course, everybody knows medical, dental, and vision. But again, remember, if medical, dental, and vision for an employer is a voluntary benefit, voluntary benefits are not subject to ERISA. If you're not subject to ERISA, then those voluntary benefits would not be eligible for COBRA. So please remember that. Now, what really defeats the voluntary benefits area is the fact that if your employer allows you to pay for those voluntary benefits, those voluntary vision or dental benefits through a cafeteria plan, that is seen by the DOL and IRS as being an endorsement of the plan, and that brings that benefit into ERISA and therefore COBRA. So you've got to be very careful to understand that. And many times, especially if you're designing an ERISA wrap plan, that's one of the decisions you have to make. Do I include the voluntary benefits inside the wrap plan? If you do, then they're subject to ERISA, and all kinds of other issues come into play here. Wellness benefits and employee assistance benefits. Wellness benefits, for example, if you have a very robust wellness program that includes medical benefits, such as areas of watching benefits, assistance in benefits, testing. If you have a very robust wellness program, the chances are, especially if you have disease management programs contained in the wellness benefits, then in that situation, then that wellness benefit is going to be considered to be a medical benefit and therefore would be subject to COBRA. You got to be real careful, and you have to. So if you have just a participatory wellness program, and you don't base it on results, the chances are that wellness program will not be considered to be a medical benefit. But over the last 5 years, more wellness benefits are contained inside a medical plan, and in that situation, of course, COBRA would apply. Employee assistance benefits. The DOL has indicated if the employee assistance program only contains referrals to other professionals, then that would not be considered to be a medical plan under ERISA. But many employee assistance programs have various types of counseling contained in them, either 5, 10, or 15 different counseling benefits that are contained inside the benefit. And the DOL has indicated that that benefit pushes it closer to being a medical benefit and therefore would be subject to COBRA. So you have to look and see what you have, what is being presented. And the lament I get from many people is, well, this employee assistance program is contained inside a disability program. Does that change anything? The answer is no. You have to look at the benefits going to be provided, and if you have detailed counseling contained inside that employee assistance program, then the chances are that benefit would be subject to COBRA. Telemedicine benefits. Telemedicine benefits, what's interesting, there's no direct guidance on this, but if you have a robust medical telemedicine program, the chances are that's going to be deemed to be a medical plan under ERISA and therefore subject to COBRA. Short-term disability payments would not be. Dependent care benefits would not be subject to COBRA. HRAs would be. It's considered to be a group medical program, and we're going to be I have some specific questions on ERISA, on HRAs in the next few minutes. Health FSAs. Health FSAs are considered to be a medical benefit, but if it's deemed to be an accepted benefit, then basically you only have to offer COBRA until the end of the plan year. So it is subject to COBRA. There's some special rules in regard to health FSAs. So please understand and remember that. Qualified small employer HRAs, again, they're not subject to COBRA. Eligibility issues. I have a series of, let's stop for a second. Julie, do we have any specific questions in regard to that?
Thanks, Larry. Everyone, once again, this is a time when you can ask questions as we go through the group. We do have a chat window on the webinar screen, so please type your questions there, and we will be sure to talk through them as they come up.
Okay.
At this time, Larry, we do not have any new questions, so let's proceed.
No problem. Thank you very much. Eligibility issues. First question, does an employer have to offer COBRA to 1099 employees if it covered them? And the answer is yes. So this has been happening more and more where an employer decides they have a number of different temporary or 1099 employees, and they decide to offer them COBRA in that situation, even though they're not employees. The law clearly says that they're covered by the medical program, and for some reason the relationship ends and their employment, in quotes, is terminated, and they're no longer eligible to participate. Yes, COBRA would have to be issued. COBRA would apply. Now, there's also other issues when you include 1099 employees in a medical program. One thing you may create is you may create a MIWA in that situation. So be careful in regard to that. Next question. Does an employee have to offer does an employer have to offer COBRA to an individual who is dropped as a dependent audit? So that should say, does an employer have to offer? In that situation, no. There's no direct guidance in this, but my opinion is in that situation, especially determining in this situation, if that person should never have been covered, then I would think that employee may be guilty of fraud in that situation. So therefore, I think you could have a gross misconduct exception there. You wouldn't have to offer, but again, there's no clear answer in this. Next question. Does an employer have to offer coverage to a spouse of an employee who was dropped from coverage at open enrollment? And the answer is no. But there's a special exception in later months. If that spouse has a divorce decree, then you as an employer would then at that time would have to offer them COBRA. So especially if this is a very common situation where somebody is going through divorce, the divorce is not finalized yet, open enrollment comes up, and that employee drops the spouse that they're going through divorce with, and at that point, you as an employer don't have to offer them COBRA, but as soon as the divorce is final, then at that point, then that spouse would have to be offered COBRA. Very important. I think these are questions you have to ask your employee. So are you going through a divorce? Because if you do, then basically one of you have to notify us of the divorce decree, and then we have to offer COBRA. Does the employer have to offer COBRA to an employee who is eligible for its retiree medical coverage? And this is a very, I think, very common situation where you work for an employer that has a retiree medical program. At the time, and generally if you retire prior to age 65, you will, as a retiree for some companies, you will continue under the active program, but you may contribute more for that coverage until you become eligible for Medicare. Now, generally in that situation, the difference in the payment of the premium is considered to be a loss of coverage. And in that situation, then as an employer, you give the employee who is retired a choice of either COBRA or the retiree coverage. At that point, what you would have to do is then, if they pick the retiree coverage, of course they will, then you would not have to offer them COBRA at the time that the retiree coverage ends. And generally, many retiree coverages may end when that person is eligible for Medicare. If you don't offer an employee coverage when they retire and they pick retiree coverage, then when that retiree coverage ends later, then you would have to offer the COBRA at that point. So again, if there's a difference, if the coverage is the same, but the payment of the premium, they're paying more as a retiree, that is deemed to be a loss of coverage. And then because you have a termination of employment and a loss of coverage, COBRA would have to be offered.
So I would like to share a couple of questions from our attendees, Larry.
Sure.
We have two that relate to EAP. And I'll read the first. This is from Lisa. Thanks for submitting your question. Will the EAP carrier provide confirmation whether the plan is COBRA eligible?
They may, but they're not required to.
Okay, they may, but they are not required to.
Mm-hmm.
Second EAP question. Under an EAP that sorry, go ahead.
That's a legal question, and that's the problem. That's a legal. They may say, well, talk to your legal counsel about the issue. They don't want to give legal opinions. That's I think what you're going to be hearing.
Okay, so that would be one to take to company counsel. Okay. And then here's a second one related to EAP. Under an EAP that offers referrals to counseling professionals, is there a COBRA liability?
No. Only if the counseling is contained inside the EAP. So some less sophisticated EAPs just have referrals to outside counselors. In that situation, the DOL has said that's not an ERISA, that's not a medical program because the benefits are not contained inside the EAP. So that's the difference. But I've been seeing more and more over the last 4 or 5 years, more and more EAPs have more sophisticated counseling benefits. And as they get more sophisticated and offer more services, that's when the EAP becomes a medical plan under ERISA. That's where the drawing line is, okay?
Okay, that's great. And then here is a new topic. Will our benefits broker be able to tell us if a wellness plan might be considered a medical plan?
If they call me and ask me, I'll tell them. But again, they can't give legal opinions. I mean, I know you go to your broker for many things, and that's the problem. And making that determination is a legal opinion.
Making it as a legal opinion.
Yes. So that's that. You got to be real careful in that regard. Okay,
great. And then this is the last question, which may or may not be also a legal versus broker question. Will Benefits Mall provide a chart summarizing which benefits are covered by ERISA, not covered, or yes, covered if? And that question comes from Hal. Sounds like that's a question specific to the Benefits Mall product provider. So I would suggest that Hal takes that there. Would you agree?
Yes, I would agree. And again, some of this is, and again, it's individual design. I mean, that's the problem. The problem is, what benefits put you over the line, and sometimes there's gray areas in that regard. Okay.
Very good. That rounds out our questions at this moment.
All right. Does an employer have to offer coverage to an employee who failed to pay his or her premium during family medical leave? The answer is no. Not until the end of the family leave. Now, I want to change my answer a bit. If that person who failed to pay the premium tells the employer, I'm not coming back from family medical leave, I'm leaving. At that point, the situation changes. At that point, then the employer then would have to, the family medical leave would end. And at the end of family medical leave, then you would have to offer the employee COBRA. Okay? Does the employer have to offer coverage to an employee who is out on workers' compensation or short-term disability? Now remember, in especially workers' comp, the employee under workers' comp only gets coverage for his or her injury, not for general medical expenses. And you have to look at your insurance policy to see if that when that person is not working, for example, not working 30 hours a week, when that coverage ends. As soon as that coverage ends and that person's on workers' comp, then you would have to, in order to continue coverage, the same thing with short-term disability, you would have to offer that individual employee COBRA. So there's two issues here. There's two issues in regard to this. One issue is termination of coverage, and the other issue is termination of employment. Clearly, under workers' comp, if they're not working hours, then you have to terminate their coverage and offer them COBRA. Next, does an employer have to offer COBRA to a former employee who waives medical coverage but wants to continue coverage under the HRA or health FSA? And the answer is, under HRA, the group coverage and the HRA are offered together. So you can't have one without the other. The same requirement doesn't apply to health FSA. And again, it's individual by individual employer. The employer may say to the employee, I'm sorry, you have to be covered under the medical program to have coverage under the health FSA, but it's not required to do so. You could, as long as coverage is offered, the employee could waive coverage and still participate under the health FSA, but there could be an employer rule that prevents that. Okay? Julia, do we have any additional questions?
Not at this time.
Okay, thank you. Coverage issues. Does a COBRA participant have the right to add coverages at the next open enrollment or qualifying event? And the answer is yes. If that person at the time of the COBRA qualifying event was covered by dental and vision, and then at the next open enrollment, that person could add medical. So the best thing to remember in regard to this, while that person is eligible for COBRA, that person is treated just like an active employee. So the special enrollment rights apply. They could add participants. That's the next question. Can a COBRA participant add a spouse or child if lost coverage during the coverage period? And the answer is yes. But please remember, in that situation, the spouse or child is not a qualified beneficiary. So if that employee then decides to drop COBRA, that spouse or child that was added during open enrollment that wasn't covered at the qualifying event would not have the right to continue coverage. They can be added, but they're not considered to be a qualified beneficiary. Next, what coverage should an employer offer to a former employee at open enrollment occurs during the election period? And this happens every so often because what sometimes happens, their enrollment period for COBRA is at the same time that your company's open enrollment is. And under COBRA, it says that you basically have to continue the coverage they had before. Well, the problem is that the coverage that they had before at the end of the enrollment period for COBRA is gone. It's going to be different. So what do you do in that situation? Do you have to offer them? And I think in this situation, because the coverage changed, I think the answer to that question is you would offer them the new coverage, even though it's different than what was offered before, but that's what's going to be continued in the future. Next, does an employer have to give a separate election under COBRA for coverage under the medical, dental, and vision benefits? It depends how the benefits are offered to the employees. If there's a separate election for medical, dental, and vision for employees, then you would have to offer the same thing. If the medical and dental are offered together and the vision is separate, then that's how it would be offered. So the COBRA participant would be treated just like an individual active employee. They would have the same elections. Julie, do we have any other questions?
We do. So I have a question that reads, if a terminated employee was not originally enrolled in medical prior to termination, do they have the ability to enroll during open enrollment?
Yes.
I was They do. Okay.
Mm-hmm. They're treated, and just remember this, and this is important to understand, while they're covered under COBRA, they're treated just like an active employee. So they have a right to add coverages at open enrollment, to add spouse or dependents at open enrollment. So the coverages can change. So at open enrollment, they're treated just like an active employee.
Great. Thank you for that question from the audience.
Right.
And let's proceed.
Okay, thank you. On regard to premium amount issues, the first question is, how often can an employer change the COBRA premium amount during the year? It's once a year, and it can only be changed under certain circumstances. Very rare can that premium change. But again, the employer sets the 12-month period. What COBRA premium is due at the end of the 45-day period? Remember, they have individuals that have a 45-day period in order to elect COBRA. There's no coverage until they elect. Okay, at the end of that 45-day period, what coverage, what premium is due at that point? And again, it depends on when that person pays the premium. And if they don't pay it to the end of the 45-day period, then it's not just 1 month. It could be 2 months. It could be as much as 3 months, depending on when the qualifying event occurred. But remember, especially in moving forward with any COBRA premium, when it's due, they have a 30-day period to pay that due premium. And that if that premium is not due by the end of the 45-day period, that premium amount is not included in the amount due. That's what I'm trying to say. So the easy answer is that you as an employer can collect 1 month easily, and sometimes 2 months, possibly 3 months, but again, depending on when they pay the initial COBRA premium. Under what consequences can the premium payments be waived or tolled? And this happened, I helped a client just a few weeks ago in this regard, and basically if the individual COBRA participant can claim and can show they were incapacitated at the time the premium payments were due. There's a number of court cases on this. They have to show the COBRA administrator that they were incapacitated. They could not act and pay that premium. So again, until that former employee shows the evidence, the doctor's evidence they were incapacitated, only under that circumstance can the premium payments be tolled, but they can be. So those are the only situation. And please remember, it's a slippery slope when you start giving COBRA participants extra time to pay for the COBRA premiums. Because if you apply to one individual, we like Mary, and Mary is a good employee and she left, and we want to give her some extra time. She's having some financial problems and we want to be good guys on this. Well, John, we're not too crazy about it. We're glad he left. And I'm sorry, but we're going to hold John's feet to the fire. And I'm sorry if you don't, pay your premiums on time, too bad. That's when employers get into trouble. That's when employers will sue, or they'll go to the DOL, and all of a sudden you're under a DOL audit, which you don't want to do. If there's no other questions, let's proceed. Let's talk about mergers and acquisitions.
One quick comment or question before we go to the next topic. What do you mean by tolled, says Jen? Is this an additional fee? Tolled, T-O-L-L-E-D.
It means that it's not due. It's not. In other words, generally you have 30 days to pay a COBRA premium. And that toll refers to the period involved. So you have a 30-day period to pay it. If you're incapacitated, what I'm trying to say is that 30-day period does not end. It continues until you're past that incapacity. That's what I'm saying. So instead of having 30 days to pay your premium, they may give you 60 days or 90 days until your incapacity goes away. That's what I'm saying.
Very good. Okay. Thanks for that clarification. We can
problem.
move on.
Thank you. Next, does the seller have to offer COBRA to a former employee in a stock sale? Now remember, in mergers and acquisitions, there's two types of transactions. There's a stock sale and there's an asset sale. In a stock sale, basically the buyer buys everything, assets and liabilities. So XYZ company, John owned it, and Mary wants to buy the stock of the companies, but the company stays in place, just the ownership changes. So the employees don't lose their jobs. So I still work for XYZ company, and I don't care if Mary or John owned it, I still have my job. In that situation, because there's no qualifying event, there's no termination of employment, the company stays in place, then there's no COBRA have to be offered. That's the issue, and many times that happens, especially if we have a situation where a company is spent, and this is where it gets complicated. Where I'm working for a company, and it used to be owned by another company, but this other company bought it, and as a result of the stock sale, I'm no longer participating in this other company's medical program. Now I have to participate under this other owner's plan. And I lost coverage under the first company, but I got it under the second company. There's a loss of coverage, yes, because we're moving away from that previous owner, but I didn't lose my job on the stock sale. So therefore, there's no COBRA that has to be offered in that circumstance. There's no qualifying event. There could be a loss of coverage because I'm moving from one company to another, but I didn't lose my job. So that's important to understand. Next question. Does the buyer have to offer COBRA to a former employee who failed to employ in an asset sale? Now remember, in an asset sale, you just buy the assets of the company, not the liability. So if I work for a company and the assets are sold, that company may still be in place. Maybe a shell, maybe a shadow of its former self, but it's still there. And the problem many times with asset sale is that that seller, after the asset sale, may go away and they may terminate their coverage. That's the problem. So does the buyer have to offer COBRA to the former employees and to fail to employ an asset sale? And the answer is it depends. It depends if the seller goes away and terminates their coverage. And many times this doesn't happen because the seller may be selling a location or a division. It's still in place, but that particular location or division is now that assets of that company, that plant, that building, and the employees that work there go with the buyer. And that's it. And so the company that sold it, the seller, is still in place, and they may still have a medical program. Okay. And so in that situation, in a asset sale, those former employees are losing their job, and the seller would have to offer them COBRA. Now let's change the facts a little bit. And the seller sells his assets. It's a shell company. A few months later, goes away. It shuts down. At that point, the buyer would then, for anyone who they haven't hired, would have to offer them COBRA. And sometimes there's a negotiation in the purchase agreement indicating who's responsible for what. So if the buyer wants to get out of the liability, they may say, seller, you promised me you're going to continue to offer coverage, and therefore we're not going to be responsible. But more often than not, the final situation comes up here. Is the buyer in an asset sale obligated to offer COBRA coverage if the seller drops medical coverage months after the sale? And the answer is yes. So the buyer has to be very careful in that situation and what they're buying, and make sure, and sometimes this is not an issue because everybody involved with the sale, all the employees go with the buyer. But again, the problem is if the seller had people that were on COBRA at the time of the sale and now the coverage is gone, they're looking someplace to have coverage and the buyer is going to be responsible. So this can get very complicated. And the issue and problem many times with mergers and acquisitions is the attorneys working on this don't know benefit issues. They're transactional attorneys. And they don't understand some of the issues and problems. And in COBRA, for example, can get rather complicated. Okay? Julia, are there any follow-up questions?
Larry, not at this time on mergers and acquisitions.
Okay, thank you. Now, this particular area is pretty messy because the roles can be very complicated. And these are three very common questions I get in regard to Medicare and COBRA. The first question is, does the employer have to offer COBRA to family members if the employee voluntarily drops medical coverage to enroll in Medicare? So this employer is over 20 employees. He doesn't have to, if he enrolls in Medicare, he doesn't lose coverage. But he decides, he looks at the figures and decides that it's cheaper to drop employer coverage and to go on to Medicare. In that situation, the issue is going to be, and this is an issue of employers, do they have to, in that situation, because the important word here is voluntary, do they have to offer COBRA to family members? And the answer is yes. In this situation, they lost coverage. It wasn't voluntary to them, and I would advise the employer to offer the family member, and that employee may be still working, for example, for the company. But here, I would advise the employer to offer the family member COBRA. Next, does the employer have to offer COBRA to an employee who enrolls in Medicare before enrolling in COBRA? And the answer is yes. If the enrollment in Medicare happens before enrolling in COBRA, then that doesn't cut off COBRA. Now it's very expensive supplemental coverage, but many times people do this. They want COBRA because they're, for example, their physician does not accept Medicare beneficiaries, people covered by Medicare, so they want to keep their as long as they can. Now, compare that with the next situation. Can an employer drop COBRA coverage for a former employee who becomes entitled to Medicare but does not enroll? And the answer is no. What's important here is the fact that you have to, in order for Medicare coverage to cut off COBRA, you must enroll. Now, the problem is, under Medicare, COBRA coverage is not considered to be employer coverage. So if you don't enroll in Medicare for 8 months, you're going to be penalized. But as soon as you enroll in Medicare, that's when your COBRA would end. So these rules are extremely complicated. These are just three particular situations I've been facing recently in regard to. So please be very careful, especially if you have individuals either ineligible for Medicare, going to enroll in Medicare. It depends on when that happens compared to when you enroll in COBRA. Julie, any follow-up questions in regard to that on Medicare?
No new questions at this time. I do have a general question or two we can hold till the end.
Sure.
Or we can address it now.
Go ahead.
Okay, great. So this question concerns the type of organization offering benefits. If an employer is subject to COBRA but not subject to ERISA, for example, state government, what requirements discussed so far might be different, if any? Are there any different requirements because it's an employer who is a state government?
I don't think there's any differences. I think probably no, because the fact there are specific notice requirements under COBRA. The only thing I would have to look at is whether the particular notice requirements under ERISA would apply to governments. because there's a number of notice requirements under COBRA. And I would have to look and see if those notice requirements would apply if you're not subject to ERISA, because they're under the labor regulations. If they're under the IRS regulations, then they would be subject. But I would have to look at and see where the notice requirements are contained.
Sure. And then this is a follow-up that may, also fall into the same category, requires more attention. But it says, particularly interested in the eligible employee dropping a spouse during annual enrollment, and then later, subsequently, the couple divorces.
And it's all a timeline. There's specific rules. It's called anticipation of divorce. And see, the problem is under COBRA, divorce is not really a qualifying event until it's finalized. So just because you file for divorce doesn't mean you're going to go through with the divorce. And the only time under COBRA that a divorce is actually a qualifying event is when there's a final divorce decree. And there are situations that divorces could take years and years and years to finalize. Until that divorce decree is final, it's not a qualifying event. That's the problem.
Okay. Okay,
all right.
Thank you. And that rounds out the questions we have live at the moment.
Okay. Health FSA issues. When can an employer deny COBRA coverage to an employee who has a balance in his or her health FSA at the time of the qualifying event? There is a rule that indicates an employer is only required to offer COBRA when their health FSA account is underspent. What does underspent means? It means you look at the remaining balance and then you compare it to what the remaining COBRA premiums would be. If the remaining COBRA premiums that the employer would pay every month are more than the remaining balance, then that account is overspent, and that employer doesn't have to offer COBRA. So in this situation, let's say that person the COBRA premium was $100 a month. And so they agreed to put in $1,200 a year. And they decide they have a qualifying event in July. And the COBRA premium for July through December would be $600. But at the time of the qualifying event, they only have $500 in their health FSA account. At that time, the employer said, I'm sorry, you've overspent your account because the COBRA premiums would be higher than what your balance is. We're going to deny you COBRA coverage. And the employer can do that. Does an employee have to enroll in medical coverage to be entitled to COBRA coverage of his or her health FSA? And again, the law doesn't require it, but your employer may say, I'm sorry, you cannot have one without the other, but it's not required. What period of coverage is an employee entitled to under health FSA? Most health FSAs, are what's called, I can't think of the term anymore, accepted benefit, accepted benefit. That means that they meet certain rules. There's very low, for example, employer contributions, and health coverage was offered to the employee. So if it's an accepted benefit, then at that there's special rules in regard to that. Under these special rules, the employer is only required to offer health FSA to the remainder of the current plan year. That's it. That's the COBRA period. So most health FSAs meet that requirement, and so that's what you see in that situation. Can an employer stop paying COBRA premium? Can an employee stop paying COBRA premiums for health FSA coverage once he or she cleans out his HRA, his FSA account? And the answer is yes. That's what many employees do in that situation once that is gone. But again, the problem is if it's lumped together with the medical, it's kind of tough to do that. So as an employer, you want to protect yourself. Can dependents elect COBRA coverage for the health FSA? Yes. The law requires it, but many employers don't offer it. But if you look at the law, it clearly indicates that dependents can elect COBRA coverage for their health FSA. let's go to the HRA issues, and these issues are different because now we're dealing with employer money, and the full COBRA rules apply to these HRAs. Can a former employee waive a group health coverage and just enroll in the HRA under COBRA? The answer is no. Usually the two coverages are tied together. Can a dependent elect COBRA for HRA if the employee waives coverage? The answer is yes. Remember, each qualified beneficiary has a right to elect COBRA, and if they are a qualified beneficiary, they have a right to do so. If each family member separately elects COBRA coverage for the HRA, what amount are they entitled to? The answer is there's no guidance on this, and as an employer, I would say if you have X amount in your HRA account, everybody gets this. So you divide up the way you want to, but I'm only, as an employer, if there's $2,000 left in an account, I'm sorry, each individual dependent doesn't get $2,000. Together, you get $2,000. I think that's the best way to handle it in that situation. How is the COBRA premium determined? In most situations, it's either determined through past experience, how much the individual spend on the account, and then that's what the individual pays for, or it can be set by the HRA administrator from their past experience if your plan is new. Dropping COBRA coverage issues. Can an employer drop coverage for a COBRA participant who refuses to complete enrollment information from a new employer? This situation crops up every so often, and the answer is the law does not allow an employer not to offer coverage in this situation. You have to work it out with the employee. I know it's tough, but the law does not give the employee under this situation the authority to say, if you don't accept this new insurer, you don't get COBRA coverage. So you have to work with the employee, make sure they agree to the new coverage. If they don't agree to it, you can't just drop them. That's the problem. Now, this comes up every so often. There's a special exception under the law if the employee has conducted gross misconduct. In that situation, the employer is not required to offer them COBRA. What is gross misconduct? It's not just a violation of the rules. They committed fraud. It's something. It would be something so egregious that the employee would not be eligible for unemployment. So it's not merely you terminated them and they violated some employee rule. It would have to be something much worse than that in order for gross, and they have to be terminated for that reason. If you found out later that they committed something that doesn't count, they must be terminated for actually engaging in gross misconduct. Okay? So, and there's no national standard for this. That's the problem. So you have to come up with a rule and apply it consistently in this situation. When can an employer drop COBRA coverage for non-payment? At the end of the 30-day period. So again, and then you have an obligation as an employer to then notify them that their COBRA coverage is terminated. So any COBRA coverage that terminates before the 18-month, 36-month period, you have to notify them as soon as possible that you are terminating their COBRA coverage and for what reason. So you have a notification issue if you're going to drop person COBRA coverage because of non-payment. Mistake issues. Because of the complexity of the COBRA rules, mistakes happen all the time. These are three very common situations. What are the employer's obligations if they do not provide a COBRA election notice to a former employee? I would advise them to, no matter what the period of time that's passed, they should issue a COBRA notice as soon as possible. Work with the insurer to see if they can provide retroactive coverage. Sometimes that's not possible to do so. So if you discover your mistake, try to fix it as soon as possible and send the COBRA notices out. I get calls all the time from employees that say, you know, I've not been offered COBRA. What should I do? Or I haven't been given a COBRA notice. Well, go to your employer, ask them, and you want coverage as soon as possible. What are the employer's options if it miscommunicated the amount of COBRA premium? In that situation, try to fix it prospectively. If there were mistakes, if it's for a long period of time, it's going to be hard to collect any money for COBRA premiums in the future. So try to fix it and move forward, and just send a new notice out and start collecting the correct amount prospectively. And this is the most common question I get in any situation. What are the consequences if an employer waives payment deadlines for one employee? And we discussed this earlier, but this is, I think, extremely important to repeat. Be very careful if you decide to waive any payment deadlines for one employee, because that, in that situation, what you're doing is you're opening up the floodgates for all the other people that are late, and you didn't offer that extension to. So please try to be very careful and not create exceptions for one employee over another. You like one employee, former employee, not another. You decide to give one employee a break, and that situation always gets out, and all of a sudden you have a DOL audit because one former employee complains to the DOL. In that situation, the DOL has to investigate that situation. How come Mary got her a premium that was 15 days late? It got accepted, but mine didn't. And I was denied coverage, and I had this operation. I had to pay $50,000, and I want restitution. That could happen in that situation. So you got to be real careful when you start creating exceptions for one employee.
So Larry, if you would, could you please repeat the first question on the prior slide? Repeat the answer regarding employers' options if they did not provide a COBRA election notice.
What I would advise you to do is send the COBRA, no matter how late it is, send the COBRA notice to the employees as soon as possible and arrange payment. Now, the problem in that situation is you could have liability if that person had expenses before that COBRA notice, but try to fix the situation, because this is one area that the DOL is very fixated on, and they will audit you. So, and try to check and see if COBRA notice has not been sent out. But even if it's 6 months late, I would send out a COBRA notice and offer that coverage as much as possible prospectively, but try to get it out there. And it's very easy to miss one or two people, especially if you have a lot of turnover in your employer. It's very easy to do that, but try to double it. And somebody terminates, try to have someone handle the fact that an election, COBRA election packet gets sent out to an employee as soon as they terminate, or there's a reduction of hours. All right. So again, even if it's real late, I would still send it out.
That's great. Thank you for that. This question concerns international companies. What if an international company closes their U.S. location, laying off all employees? Do they need to offer COBRA, and if so, how would it be administered?
Well, in that situation, they have to, because I would imagine they would have to continue their coverage for those employees for the 18-month period. They have to offer some coverage. And let me amend that.
Because their employees were U.S.
Well,
based.
After thinking about that, if, for example, a company had a location in the United States, and they closed up shop and left. A company in particular, a Japanese automaker, was selling cars in the United States, and they decided to leave. And they had 500 employees. And they decided in August, we're going to close our U.S. And we're not going to have any employees in the United States. We're going to offer anything. In that situation, and they decided to terminate their U.S. plan. There's no longer going to be a U.S. plan. And the only plan that's going to be offered is for the employees in Japan. In that situation, I would think, because they don't have any U.S. Plans or U.S. employees, they would not have a COBRA obligation. That's my opinion. But if they had one small division in the United States and they had 2 employees and they offered coverage to 2 employees, then my answer would change. So if they left and they have no employees in the United States, no plans, there would be no COBRA obligation. Okay?
Okay, thank you. This one is in reference to the question, if the employer did not provide a notice, what is the obligation after the 18-month window?
If you don't offer coverage, there's going to be liability. I mean, that's the problem. You still have an obligation to send out that COBRA notice. Mm-hmm. And whether it goes away because, the chances are that employee probably has another job and didn't want COBRA, but you still have the obligation and there's still penalties for not providing a COBRA notice. So you still have some obligation. And as time goes on, it's going to be less likely you're going to be dinged in this situation. But you still haven't done what and there are penalties for not providing a COBRA notice. Mm-hmm. So you still have liability.
Okay. And then just regarding the notice itself, is a letter that doesn't include the forms for COBRA, but does include information about the former employee's rights, tells them who to call, how to handle. Is that considered sufficient notice, or is there a reference that you would advise for determining what constitutes the notice? What is required?
Well, there are regulations in what the COBRA election notice has to contain. And if you didn't meet those requirements, if you just provided some material and not others, you didn't meet the regulations. So I think it's treated as if you didn't give the notice at all. So there are detailed rules under the regulations of what should be contained in that COBRA election notice. You have to provide, what coverage, what the cost is, what the period is. All those rules would have to apply. Would have to be, and there's a detailed election COBRA notice. So you have to provide that, and then the election forms. So if that's not provided, I don't think you've met the requirement.
Very good. Thanks for that. And I believe that wraps up our questions for the moment. We are at the top of the hour. Larry, do you have a minute or more to stay on if we receive another question?
Sure, no problem.
And I do want to share with everyone that we do provide slides after the webinar. A couple of attendees have asked whether the responses or the answers to these questions will be provided. What I recommend is bookmarking the webinar recording, and we will take back the request for a Q&A kind of document and talk again about that. Okay, and I do have just one last question. Looks like this one's from Michelle. Returning to the topic of Medicare, if the eligible employee was not previously in the group plan, let me start again. If the family member was not previously enrolled in the group plan when the employee drops medical coverage to enroll in Medicare, does COBRA need to be offered to the family or dependents?
No. One of the requirements of COBRA, you have to be covered at the qualifying event. So if they're not covered, they wouldn't be. Okay?
Okay, very good. That is our last question.
Everyone, if you like this method of having a seminar, let Julia know and let Benefit Express know, because I like doing this because it It covers a lot of area, plus it's based on true life situations. So if you like it, even if you didn't like it, and you said, "Oh my God, this was stupid, I hate it," tell us, please. Tell us one way or the other if you like it or didn't like it, because that's going to determine the structure of anything in the future. Okay? We enjoy getting feedback of any kind.
Absolutely. And we look forward to hearing your feedback on this new format. We're getting some thumbs up, so thank you for that. As always, if you have interest or ideas and topics to cover, we're all ears. Please reach out, and we'll be happy to incorporate your thoughts in our upcoming webinar schedule. All of our webinars.
Our seminar in May is going to be on HSAs, right?
Yes, that's right, which is a hot topic.
And I may do a similar seminar on this with a number of different HSA issues. So if you like this, I'll design it the same way, okay?
Okay. There we have it.
All right.
Thanks, everybody. We appreciate your time today. Enjoy the rest of your afternoon.
Take care. Bye-bye.
Thank you. Bye-bye.